Yes, Mr. Adkin.
Good afternoon. In answer to my Lord Justice Nugee's question before lunch about payments 1 and 2, the position as we see it is this. In light of the judge's findings at paragraph 63 and his final paragraph of the judgment, i.e. that I can't remember the precise figure, $10 million had been allocated by Rasmala to payment 1 and payment 2, and that if he had to decide the question of whether that allocation could be disturbed or reallocated, he would have found against Rasmala. In light of those findings, we accept that we are not entitled to pursue restitution in relation to payment 1, and most of payment 2. The figures don't completely eliminate the entirety of payment 2, but we obviously say that what happened in relation to payment 1 and payment 2 needs to be understood in the broader context of the causation debate. So that's our answer to my lord.
It's about 11.2 million.
Yes,
taken
something like that
together.
Now, I think it comes to just below the aggregate of payment 1 and payment 2.
Yes, payment 1 and payment 2 comes, I think, to about 11.2, and the payment that you allocated was about 10.5.
Yeah. So that's that. I'm going to now conclude on causation. I should mention the Commerce Bank case, which is a decision of this court. It's in the skeleton arguments. It doesn't take matters any further. In my submission, it is simply a case on rather different facts. In causation terms, we accept that but for the payments, there would have been no change of position, but we say that is the wrong test. The payments on their own would not have resulted in the change of position. The change of position causatively required the TPAs, in which Rasmala was not involved, about which it knew nothing, and from which it can in no sense bear any responsibility. And we submit that in such a case, where the relevant events comprise the making and receipt of the payments on a particular basis, followed by something else, a separate step or event, undertaken by a third party, which brings about a change of position, the but-for test is inapposite. It does not reflect the basic principles which underpin the change of position defence. The high-level issue where the change of position defence is sought to be engaged is always whether it is unjust to allow the claimant to have restitution in whole or in part, and that depends, as Lord Justice Aikins put it in Haugesand, on whether the defendant has so changed its position that the injustice of requiring him to repay outweighs the injustice of denying the claimant restitution. The causation requirement in relation to that defence needs to be approached with that principle in mind. It is true that Rasmala's mistake created the circumstances in which the change of position was able to take place, but there is, we submit, an obvious and significant difference between a case in which the payer's mistaken payment on its own brings about the change of position, and a case such as this, where the payer's mistaken payment does not have that effect, but the change of position is brought about by a further step taken by a third party for which the payer can be said to have no responsibility. So that is why we say that a but-for approach in such a case is simply too blunt an instrument, and that the correct approach is one of reliance or on the faith of the payment, which both communicate the same basic idea. So that brings me to the next ground of appeal, which is ground 3, concerned with the allocation of risk. I want to spend not very much time on this, but a little time, because it has particular significance in relation to payment 5. And the authority we need to look at is Haugesand and Deptford, which we have at tab 9 of the authorities bundle. We've already looked at the allocation of risk analysis in rows. You'll recall, I'm so sorry, tab 15. In rows, you'll recall that was the alternative way in which the judge looked at the situation. And in Haugesand, that was one of the swaps cases. it's at tab 15, page 382. Two Norwegian local authorities had entered into swaps agreements with Deptford, under which Deptford agreed to advance to those authorities a capital sum. The authorities then invested the sums advanced in various instruments which turned out to be loss-making. To avoid having to repay Deptford, because the swaps were held void, the local authorities, to avoid having to repay Deptford, the local authorities argued that the swaps were ultra vires under Norwegian law and therefore void. That argument was accepted, but the bank counterclaimed for restitution, and the Norwegian authorities sought to argue that they had available to them a defence of change of position, that change of position being the loss-making investments that they had made. Much of the appeal was concerned with the very complex issues around the swaps, but since it was found that the claim was on the face of it available, the change of position defence was addressed. Lord Justice Aitken, with whom Lord Justice Pill agreed, gave the lead judgment. And his analysis of the change of position defence starts at page 421, at paragraph 109. I'm not going to take you through all of this in detail. He conducts a detailed analysis of the law, and then he arrives at a summary at paragraphs 122 and 123 on page 425, which we've already read this morning. And he analysed the application of the principles to the facts before him at paragraphs 124 to 126, which we should just have a look at. So reading from 124, this case is concerned with the second of the two situations I have identified. The communes understood when they took the money from Deptford that they had to repay it, ultimately in the last bullet repayment at the end of what were thought at the time to be valid agreements. Admittedly, those agreements were always void, but that cannot change the understanding on which the communes received the money. At no stage did they think they had received a gift that would never have to be repaid. Furthermore, if the swaps contracts were void, then the cause of action for the claim and restitution for consideration that had wholly failed must have arisen at the moment the money was paid over to the communes. I would accept that the communes would not have made the investment from via terror that they did, but for the receipt of the sums from Deptford. I also accept that the communes acted in good faith in making the investments, and that any question of negligence or other criticism of those investments is irrelevant to this defence. But the communes made those investments without any involvement by Deptford, and the communes made them on the understanding at that stage in the history that they had to repay the principal and interest to Deptford whatever happened to the investments. As Professor Vergey puts it in his book, it is a question of risk allocation. The communes took the risk in this case. There is no basis upon which the defence of change of position can succeed. So it seems to me the question here is this: where lies the justice of the case in favour of the party that received the money and took the risk in good faith that the investments might go down rather than up, or in favour of the party that paid over the money and had nothing to do with it thereafter, but thinking it was to be repaid in due course? Like Mr. Justice Tomlinson, I think the answer to this question is obvious. The scales fall heavily in favour of Deptford recovering the full amount that it paid over to the communes. So Lord Justice Aikens accepted that the communes had acted in good faith. He accepted that they would not have made the investments that they did but for the receipt of the sums from Deptford, though of course he doesn't express any view as to whether that alone would be sufficient. Lord Justice Aikens' conclusion was that nonetheless the change of position defence did not work because the communes understood when they received the payments that they would have to be repaid. They'd taken the risk when they invested the monies in the investments that they investments might suffer a loss, and having taken that risk it was not inequitable to require restitution to be made, and that might be thought to be an entirely appropriate and obvious outcome. As Lord Justice Aikens said, the bank in that case simply paid the money over and had nothing to do with it afterwards, thinking it was to be repaid in due course. It had no involvement in the investments, no involvement that led to the steps that led to the change of position, and it would be unjust in such circumstances to deprive it of its restitution claim. Now, our case is obviously very different, but one can see how the analysis transposes. Trafigura knew that it needed to obtain Rasmala's consent before it could apply the payments to discharge Farlin's historic debts. It knew that if no TPA was obtained, it would have to return the monies. It must be taken to have known that if the TPAs were invalid, it would have to return the monies. We recognise, of course, that in Hankasand, the communes can fairly be said to have been taking the risk that the investments might perform badly advertently. They plainly knew when they made the investments that they might go, as it were, to use the phrase, down as well as up, and in consequence that the sums available to repay the bank might be reduced. And that's obviously a distinction with our case, at least as regards payments 1 to 4, where on the judge's findings, Trafigura did not know or suspect that Rasmala's signature on the TPAs might turn out to be false. But we do submit that the allocation of risk of the TPAs turning out to be forged and the use of the monies which led to Trafigura changing its position being unauthorised, that allocation should be allocated to Trafigura, not Rasmala, because it is Trafigura, which was the only party that could have avoided the risk of the TPAs being forged. Since, just as Lord Justice Aikens observed in Hankasand, the bank had nothing to do after paying the monies over with the investments. So in our case, Rasmala had nothing to do after paying the monies over with the TPAs.
Could they have taken any steps to address the risk?
Trafigura?
No, Rasmala.
No, they were completely unaware of the TPAs.
But they just paid the money.
They did. They did.
They didn't. They didn't do what you say Trafigura should have done, which is contact the other side.
I accept that. But they paid the...
So why are you say it's right to say that Trafigura should have contacted Rasmala, but not that Rasmala should have done anything to approach Trafigura when it was making the payments?
It's a slightly different point. And the point is this. What led to the change of position was the TPAs that we previously discussed. And it's quite a short point, really. Trafigura could do something about checking that it was authorised to allocate the money as it believed it was. Rasmala could do nothing about that because Rasmala knew nothing about the TPAs. Rasmala was paying the monies on a certain basis, believing that they would be used on a certain basis. That basis shifted in the mind of Trafigura after the receipt of the first payment, and Trafigura didn't take any steps to contact Rasmala directly, and it could have taken those steps. It could have investigated the TPAs. Rasmala knew nothing about them.
So you're pointing to, again, the TPAs, the process around them as making all the difference.
Yes. Yes, we do say that. Yeah, the TPAs are critical.
It's just not true to say that there's nothing Rasmala could have done. Rasmala could have made it perfectly clear when paying Trafigura the limits on Trafigura's ability to use the money. And as you said right at the outset, it didn't do that. It didn't communicate with Trafigura. It left for reasons that I think remain obscure, but it left to Farlin to deal with Trafigura.
Trafigura, yes. I appreciate that point, my lord. But the submission is a short one. I'm not sure I can improve it.
No,
It's what led to the change was the TPA. Sorry, I didn't want to.
Was reliance on TPA.
It was reliance on the TPA, and in terms of risk allocation, one can see
that was a risk you say Trafigura took, not a risk.
Exactly. And in relation to payment 5, that point assumes a particular significance.
Well, there it's a different risk. It's the risk that the TPA will in fact be signed.
Exactly.
Can I ask you something else that comes out of paragraph 126? Lord Justice Aiken seems to ask quite a broad question: where lies the justice of the case? And that echoes something that I think Mr. Justice Munby said in one of them,
Commerce Bank.
in Commerce Bank, which is these are not discretionary decisions, but it is a judicial evaluation of whether there's an injustice or where the injustice lies. Is that a correct way of looking at it?
Yes and no. Yes, in the sense that there is an evaluative process involved. But in my respectful submission, no, in the sense that the evaluative process has got to be by reference to some principles. And with respect, in my submission, those principles have got to be a little more developed than simply the balance of the equities, because...
Well, Mr. Justice Mumby rather dissuades the court from setting up technical rules and boxes to tick and sophisticated distinctions,
Yes.
and fall back on the ability of the court to recognise inequity when it sees it. Is that unfair? It's a characterisation.
One tempted to say something about the Lord Chancellor's foot. That's the difficulty with that. I don't...
It's not, he's clear that it's not a general discretion, as indeed Lord Gough was.
Yes.
But he does say we want to be careful of getting all these fine distinctions and go back to a judicial evaluation of whether it's unconscionable or not.
Yes.
And it's not really what just Mr. Justice Mumby, it's really what Lord Justice Aikins is saying, isn't it? As
Well,
well?
that's what
In
made
the
me think
first
of it. Is Lord
paragraph.
Justice Aikins
Yes.
seems to be approaching it from a similar perspective. Where does the justice of a case lie?
And the echo is also there in Lord Gough, isn't it?
Yes.
And
Yes.
for that matter, Lord Mansfield.
Yes. There's no doubt that, and this is repeated throughout the authorities.
You can't hear me, but don't worry, that's at least that's a good thing.
There's something's happened to your microphone.
Okay, all right.
Yeah, sorry.
Okay.
I'm
Technical problem.
sorry to interrupt.
Only my
I would
mild joke about Lord Mansfield was missing. Yes?
I accept, as I must, that certainly the early cases and indeed the observations of Lord Mumby and Lord Justice Aikins here are framed in general terms. But there have to be guidelines, and one of those guidelines is there has to be the necessary causative link. And in a sense, talking about it in terms of the balance of injustice or what have you is a fair way of approaching it. But what's required causatively needs to be considered in the context of that, and we discussed that before lunch. And in this case, where the allocation of risk should lie needs to be considered in that context. But it doesn't excuse you from having to go through that analytical process, in my respectful submission. The problem with an observation, where lies the justice of the case, is what does one do with that?
Well, one thing you might do with it is you say, if this is really an exercise in judicial evaluation of whether something is unjust or unconscionable or whatever, that might inhibit the appellate court from interfering quite so readily, because the appellate court interferes readily when there are errors of law, but much less readily if there are judicial assessments that are said to be wrong.
Yes.
So I think we do need to understand what is the exercise we're engaged upon.
Yes. Well, the exercise that you're engaged in, I would submit, is that we say the judge got it wrong, and we say the judge got it wrong for analytical reasons. That's not a question of evaluation, that's a question just applying the wrong approach. And so it's not one of those cases, we say, where you've got to identify relevant things that he should have taken into account and didn't, or irrelevant things that he shouldn't have did, or plainly wrong. It's a different exercise.
He asked the
Our
wrong
submission
question.
is he asked himself he asked himself the wrong question on causation, for example. He
Yes.
applied the wrong test, but he asked the wrong question and he elided different
Okay.
steps.
I think I can understand that on causation. We're on a different topic, or apparently different topic,
Yes.
risk allocation.
That's evaluation, isn't it?
How
Well-
can you apply? What do you say about that? Where did he go wrong?
Let me show you.
Go wrong in a way
By reference
with
to
which
judgment.
this court can interfere.
Yes, let me show you, if I may, by reference to the judgment. because it's at paragraphs 101 to 102 of the judgment. That's what we're concerned with. Core bundle tab 7, page 91. And it's paragraph 101. Perhaps you would just quickly read that, but perhaps I can answer my lady's question before you do. We say that the analysis is simply wrong in critical respects. It is true that in the present case, the nature of the risks to be allocated is different from that arose in Haugesant. In Haugesant, the monies were received by the communes knowing that they would have to be repaid. They invested those monies in loss-making investments and therefore took the risk of that loss. In this case, the monies were received by Trafigura knowing they would have to be repaid if there was no consent from Rasmala to their use in paying down Farlin's debt. Trafigura used the money to pay down the accrued debt as it thought on the basis of the TPAs, and that's what led to the change of position. And it was the risk that it was not so authorised. That's what we're concerned with here, and that's what we say should be allocated to Trafigura. But what the judge says in the middle of paragraph 101 is it didn't matter whether internally the payments were treated by Trafigura as discharging a historic debt of Farlin or treating as discharging a new debt of Farling, says that's immaterial. But it absolutely wasn't immaterial. As he found himself earlier in the judgment, it was highly material to Rasmala that they weren't used in that way, and it was critically important to Trafigura because
but is that what he's saying? He's more making the point. I think he's addressing a different point, which is in contrast to the Haugesand case. I don't think we're readily going to assume he's forgotten what he said a few paragraphs earlier, which is what your submission amounts to.
Well, it's the sentence 1, 2, 3, 4, 5, 6,
No,
7,
I've
8,
got the
9.
sentence.
Yes, whether internally.
What? Can I just
No,
check?
but you have to read what is said. It's paid with the intention and received with the understanding. It's
Yes.
the contrast of an outright payment and a loan. which
Yes.
is commercially a loan.
Yes. Well, the answer is that again, perhaps we can keep this. I'll try and take it as shortly as I can. But we say that it is true that the position in this case is obviously different to Haugesand, but what the judge doesn't do is identify the risk to be allocated, namely the risk that the TPAs are false. And the reason he doesn't do that is because, for whatever reason, in this paragraph, he seems to be proceeding on the premise that it didn't matter to either Trafigura or Rasmala. And that's wrong. It absolutely did matter, both to Trafigura and to Rasmala.
So as with causation, where you focus on the TPAs and say that's causative, similarly on risk allocation, you say the risk all relates to the validity or otherwise of the TPAs, and
Yes.
that can only
Yes.
be a matter for Trafigura.
Yes. Exactly. What is the risk we're concerned with? It's at the end of the day, it's the risk that Trafigura was not authorised to use the monies as it did. What did the eventuation of that risk turn on? The TPAs. Where should that risk be allocated? Trafigura, because it and not Rasmala had view of the TPAs. That's the point.
Can I pick up something you said, which was it absolutely did matter, both to Trafigura and Rasmala, how the money was used. Why did it matter to Rasmala? This is a point taken in your opponent's skeleton. Why did it matter to Rasmala whether it was used to pay historic debts or new debts? And I understand that it could have made a difference if using it to pay a new debt actually gave them security. But we saw right at the outset that although it was set up in such a way as to give them security, they never actually got security. So why did it matter what it was used for?
Well, two answers to that. The first is it's a Sharia lender, so it matters for that reason. putting aside questions of security, it simply wants to be engaged in not lending in breach of Sharia law, but buying coal. So that is important to it.
Yes.
Secondly, the evidence was that it mattered. Whatever the reason might be, in a sense, is neither here nor there. The evidence was that it did matter to
So,
Rasmala.
Thank you.
in its view of the world, it was acting as the principal
Yes,
on particular purchases of coal. And I think I understand from that point of view that it wants to make sure that its purchases are paid for.
yes. It does not want to be paying down the accrued debt. Firstly,
Yeah,
for that
Because
commercial
it's
reason.
the principal,
And second-
unbeknownst to
Yes, undisclosed.
Trafigura,
Yeah.
it's the principal, so it wants to pay for its own coal.
Yes. What it doesn't
rather
want to do is
than
be a
someone
lender.
else's coal.
Exactly. It doesn't want to be a lender because that's
Yeah.
you understand the point.
Is it fair also to say that it didn't want Trafigura to know that it was the purchaser of coal? It was an undisclosed, intended to be an undisclosed principle.
Well, it was not intended to be a disclosed principle. Whether it mattered, whether Trafigura knew it was the buyer of coal or not, I'm not sure. I don't know what the evidence said about that.
I'll show you the evidence later.
Okay, well, we look forward to that. But in any event, it doesn't matter. I mean, Rasmala must have known that Trafigura would know that it existed because that's where the payment came from. So,
Yes, but there is a difference between providing financing for someone else's contract and taking a contract in your own name,
of
obviously.
course, yes, of course, I understand that. So that's what I wanted to say about risk allocation. The ground 4 of our grounds of appeal is the good faith point, which may not be the sort of good faith is referred to, I think, in the authorities following Lord Gough, but it looks like it may have become a bit of a misdescription, or possibly a diverting description, but we'll look at the case in a moment. You'll recall the requirement that a defendant seeking to rely on a change of position defence has to act in good faith, or at least not act in bad faith. That requirement was identified in Lord Gough's speech in Lipcombe Gorman, and we saw that. What that actually means, or has been taken to mean, has been developed in the subsequent authorities. And the authority we need to look at is a case in this court called Nairu Battery, which is at tab 11 of the authorities bundle. And page 305, tab 11. The facts were fiendishly complicated, but so far as presently relevant, the relevant defendant was a bank which had received a payment of which restitution was sought. It had paid the money away to its customer and relied on a change of position defence. The evidence which the trial judge accepted was that the relevant manager of the bank realised the monies had been paid by mistake, but believed he owed no duty to inquire of the paying bank, but did owe a duty to its customer, and so paid the money away to its customer. And Mr. Justice Morbick, at first instance, as he then was, held that the manager had not acted dishonestly, in that he had not consciously acted in disregard of the standards to be expected of the ordinary honest banker. But the trial judge nonetheless held that the change of position defence was not available because the defendant had not acted in a commercially acceptable manner, as the manager had made no inquiries of the paying bank. On appeal, the defendant contended that in the absence of dishonesty, the change of position defence should have succeeded, saying essentially that dishonesty and good faith for these purposes were synonymous. And the Court of Appeal upheld the first instance judgment and disagreed with that argument. And Lord Justice Clark, as he then was, gave the lead judgment, and his analysis starts at page 318. And he goes through the principles and paragraph over the page at 320 at paragraph 149 he says, as I read the speeches in Lippick and Gorman, the essential question of whether it would be inequitable or unconscionable and thus unjust to allow the recipient of money paid under a mistake of fact to deny restitution to the payer. So again, it's the big picture, broad question. He then analysed the various authorities, and he set out his conclusion at page 323, paragraph 162. I have reached the conclusion that the authorities support the proposition already stated above, that the essential question is whether on the facts of a particular case it would in all the circumstances be inequitable or conscionable and thus unjust to allow the recipient of money paid under a mistake of fact to deny restitution to the payer. As I read his judgment, the judge reached the same conclusion and was, in my opinion, correct to do so. It follows that I would accept Mr. Block's submission in para 144, but would not accept his submission 2, because I do not accept that a payment away is made in good faith in this context unless it is made dishonestly. The question remains in what circumstances a bank will be held to have acted otherwise in good faith. The answer is, of course, it all depends upon the circumstances, so that it is not possible to lay down absolute principles. However, the judge addressed the problem in his judgment, which included the following. And I'm going to read this passage because Lord Justice Clark agrees with it. So this is Mr. Justice Morbick. I do not think that it is desirable to attempt to define the limits of good faith. It is a broad concept, the definition of which, insofar as it is capable of definition at all, will have to be worked out through the cases. In my view, it is capable of embracing a failure to act in a commercially acceptable way, and sharp practice of a kind that falls short of outright dishonesty as well as dishonesty itself. The factors which will determine whether it is inequitable to allow the claimant to obtain restitution in a case of mistaken payment will vary from case to case, but where the payee has voluntarily parted with the money, much is likely to depend on the circumstances in which he did so and the extent of his knowledge about how the payment came to be made. Where he knows that the payment he received was made by mistake, the position is quite straightforward. He must return it. This applies as much to a banker who receives a payment for his account of his customers to any other person. Greater difficulty may arise, however, in cases where the payee has grounds for believing that the payment may have been made by mistake but cannot be sure. In such cases, good faith may well dictate that an inquiry be made of the payer. The nature and extent of the inquiry called for will, of course, depend on the circumstances of the case. But I do not think that a person who has or thinks he has good reason to believe that the payment was made by mistake will often be found to have acted in good faith if he pays the money away without first making inquiries of the person from whom he received it. I agree. Now, Lord Justice Sedley also gave a judgment in which he considered the good faith element, and I don't think I need to take you to it. And President Butler Schloss agreed with both judgments. 333. Now, we say, obviously, it's right that the good faith concept is not limited to dishonesty. It encompasses cases where there has been a failure to act in a commercially acceptable way. And as we say, right is in an area of the law which is built on the concept of what is or is not inequitable. Such an approach to the good faith element is appropriate, we respectfully submit. So let's look at what the judge found in relation to the good faith element. In this case, it is at Core Bundle tab 7, page 92. And the judge addressed the matter starting at the bottom of page paragraph 109, and he cited the Nauru battery case and also made reference to Commerce Bank, and then he dealt with the guts of the argument at paragraph 111 and 112. Rasmala says that Trafigura was on inquiry as to whether Rasmala had consented to the TPAs. This is because Trafigura understood that Rasmala had made payment 1 in respect of future deliveries, and the email sent initially by Farlin when presented as TPA 1 was that Rasmala would never sign a TPA permitting the application of payment 1 for historic debts. And we looked at that part of the story this morning. Rasmala also relies on the fact that there were other anomalies. Trafigura's Treasury team were clearly unable to match the payments to existing invoices and asked to which debts they should be allocated. further Trafigura's standard practice of copying in the third party in communications and its standard practice as to which bank account payments were to be made to were not followed. In failing to make inquiries of Rasmala directly, Rasmala says that Trafigura's approach was casual and insouciant and not as a reasonable person would have acted. I reject that submission. These matters fall a long way short of establishing that anyone at Trafigura had knowledge of facts which gave them, or should have given a reasonable person, reason to believe that the TPAs had not been signed by Rasmala or that the payments were repayable. The never email, which is the high point of why Rasmala says Trafigura was or should have been on inquiry, is an unremarkable example of the to and fro of commercial negotiation, and it did not have the immutable status to which Rasmala sought to elevate it. The fact that Farley relented and later said it had managed to persuade Rasmala to enter TPA1 was not a red flag. I am satisfied that Trafigura's acceptance of the payments and continued trading with Farley in consequence was without knowledge or suspicion of anyone at Trafigura, and the TPAs were invalid, all the payments were the TPAs were invalid, all the payments were repayable, and was in good faith for the purposes of change of position defence. Now, the key findings come at the end of paragraph 11 and 111 and the beginning of 112, where he said that he, quote, I reject that submission. The submission he's rejecting is obviously the final sentence of paragraph 111. So he's rejecting the submission that in failing to make inquiries of Rasmala directly, Rasmala says that Trafigura's approach was casual and insouciant and not as a reasonable person would have acted. But it's also clear that he's rejecting that submission for the reason he gives in the next sentence of paragraph 112 and indeed the rest of that paragraph, which is also reflected in paragraph 113. In other words, what the judge focused on was the rather narrower question of whether Trafigura knew or should have known that the TPAs had not been signed by Rasmala. And we submit that is an error of approach. No doubt if he had concluded that Trafigura knew or suspected that the TPAs were forged or that there were red flags, that would have been a significant factor in determining whether Trafigura had acted in good faith or acted in a commercially acceptable way. But in our submission, that is not the end of the analysis. Even if there were no red flags, even if it did not suspect, it doesn't follow that Trafigura is to be taken as having acted in a commercially acceptable way in failing to take the very simple and easy step of contacting Rasmala directly to ask whether it approved of the proposed use of the funds. And it
how do we gauge what is commercially acceptable in this very particular context?
I think one has to use one's commercial common sense if one can get away with that phrase.
But I stress in the particular context
Yes.
that we're dealing with this type of transaction,
Yes.
where Sharia principles are in the background influencing everything that everybody's doing.
Yes.
You're trying to identify an error of principle, but isn't this this is the judge applying the test that you say he should?
Well, in our submission, no. So where the judge has gone wrong is he's answered the question, did Trafigura act in a commercially acceptable way, solely by reference to whether or not it knew or should have known that the TPAs had not been signed by Rasmala and the payments were therefore repayable. That's paragraph 112. What he hasn't considered, because he's adopted that too narrow an approach, is whether, even if Trafigura, as he found, did not know or suspect, and should not have known or suspected, that the TPAs were forged and the payments were required to be repaid, it nonetheless acted in a commercially unacceptable way. And we submit that the answer to that question is it did, because it was a party which received unheralded into its account monies from an unknown third party, which it was told by somebody else was to be used for that somebody else's benefit, but which it failed to contact the payer directly to make sure of. And we say that is a commercially unacceptable approach. To rely on the person who is telling you they're going to benefit from the payment. Let's just put it in the simplest of terms. If a party received a very substantial sum into its bank account from somebody it has never heard of and never had any dealings with before, and one of its debtors says, "That's for me," the recipient, we submit, can be expected to check with the payer that the money is indeed for the debtor and not just rely on the say-so of the debtor itself, especially in circumstances where it would be very easy to check with the payer. And because of the, we say, erroneous approach that the judge developed and took, he didn't ask himself that simple question, and we submit, therefore, he was in error. My lords and my lady, that brings me to the final ground that we rely on, which is ground 7 of the grounds of appeal, which is payment 5. And the judge addressed the relevant facts in relation to payment 5 at page 80 of the full bundle, paragraphs 53 to 56. So you can pick it up at page 81, paragraph 55. The judge said, over at Trafigura, Mr. Samdani sent Mr. Gokhale the SWIFT for payment 5 on the 22nd of April 2018, following the usual course of action on the 22nd of March 2018. Mr. Gupta requested a TPA from Farlin and provided the proposed allocation for payment 5. Trafigura never received a TPA despite follow-up requests. Sometime in March 2018, a management meeting took place in Mumbai. The allocation of payment 5 was discussed and it was decided that payment 5 should be allocated to Farlin's outstanding debts. From Mr. Gokhale's evidence, it seems that Trafigura assumed that a TPA would be forthcoming eventually from Farlin. So the judge found Trafigura requested a TPA in respect of payment 5. None was forthcoming, but notwithstanding that, the monies from payment 5 were allocated to pay down Farlin's outstanding debts, on the assumption, to use the judge's word, that a TPA would, in the event, be forthcoming. And we can just perhaps briefly look at the evidence on this, which reflects what the judge found. If we go to supplementary bundle tab 3 at page 55, this is Mr. Gokhale's evidence. This is his witness statement. If we go to page 74, paragraph 88, he refers to the only exception to the process being the final Rasmala payment. He only vaguely recalls it. He doesn't think that Farlin ever sent a tripartite agreement for that payment. They followed up with Farlin about it. Farlin kept saying they would send over the TPA, but it never came. There was a meeting in the Mumbai office to discuss it and whether we would allocate the payment internally without a tripartite agreement. Several members of management were present. He doesn't recall anybody at the meeting raising any concern that Rasmala might not have consented to its payment. We had tripartite agreements for the previous 4 payments. The 5th payment seemed to be similar. That helped everyone get comfortable. Ultimately, the decision to allocate the 5th Rasmala payment without TPA was taken by management. So that's his evidence, and we can also see what he said in cross-examination at tab 7, page 198. If we go to internal, page 72. So this is Mr. Gokhale being cross-examined, picking it up at line 17. No tripartite agreement was signed in relation to the 5th payment. Do you recall? Yes, we asked Farlin to sent in the allocation after we received our 5th payment, and we asked for the assigned TPA from Farlin, but we didn't receive it. So you had no basis, Trafigura, for applying the monies to historic debts, did you, this payment? That is something that was not under my authority to do. Okay. And if we go down internal page 73 to line 20, the fact that there was no TPA in respect to the fifth payment prompted a meeting in Mumbai. Yes. That was attended by members of management. Yes. Management attended and the meeting was called because having a TPA was important from Trafigura's perspective. For allocation, yes. For allocation, because its purpose was to allow Trafigura to retain the monies and apply them to historic debts. Correct. Now, it is true, as I mentioned this morning, that at paragraph 43 of the judgment, the judge found that after payment one, Mr. Gokhale and Mr. Gupta of Trafigura at least did not realise that Rasmala was making its payments in respect of a specific future contract. But that doesn't matter, we submit. What happened in relation to payment 5 is that Trafigura unilaterally decided to allocate the payments it had received from Rasmala to Farlin's outstanding debts. It did that on the assumption, as the judge found it, that a TPA would be forthcoming and that they would therefore obtain authorisation. And unlike payments 1 to 4, in relation to which Trafigura can at least say it allocated the payments received by acting on the faith of the TPAs, and therefore at least ostensibly on the basis of Rasmala's consent, there was no basis for Trafigura's decision to allocate payment 5 to Farlin's historic debts, other than its own voluntary decision to proceed without authorisation on the assumption that such authorisation in the form of a TPA would be obtained.
Wasn't the commercial context by this time that TPAs would be forthcoming?
It was.
Because of a course of well-established course of dealing.
It was certainly the expectation that the TPA was forthcoming, but they asked for it. And they didn't, the position wasn't that because of their course of dealing, they didn't feel they needed a TPA at all. In relation to payment 5, you'll recall, we saw the evidence and the judge's findings. They asked for a TPA and repeatedly asked for it. They pressed Farlin for it a number of times and they didn't get it. And notwithstanding that, they decided to allocate and change their position on the basis of the allocation. And the simple points are, 1, they changed their position an assumption that they could allocate payment 5 in the way that they did, which was wrong. And they took the risk that payment 5 might have to be returned to Rasmala. They understood they needed to obtain Rasmala's authority to allocate. They asked for that authority, but they were willing to allocate without getting it. And it really can't matter whether the allocation that they would have got would, on this hypothetical counterfactual, have been forged. They can't be in a better position just because the TPA was forged. They can't be in a better position than they would have been if the TPA signatures for TPAs 1 to 4 had actually been genuine.
Does this go to causation, risk allocation, or both?
It actually goes to causation, it goes to risk allocation, and it goes to good faith. So in terms of causation, we say that payment 5 wasn't caused by that the change of position in relation to payment 5 wasn't caused by the payment at all. It was caused by an erroneous assumption on the part of Trafigura that it could allocate the payment in the way that it did because it was going to get a TPA. So that's the causation point. In terms of risk allocation, Trafigura took the risk that its allocation would not be authorised. It knew it needed to obtain Rasmala's consent to allocate as it proposed to do. It asked for that consent, it didn't get it. It took the risk that the consent wouldn't be forthcoming and that it would turn out that it would not be authorised. And it can also be analysed through the lens of the good faith requirement. Is it commercially acceptable? I mean, the argument on good faith from the other side is, well, it was commercially acceptable for Trafigura, having received the payments from a completely unknown third party, it was commercially acceptable to allocate them as they did because they got these TPAs and they didn't know and they had no reason to know that they were forged. But that answer doesn't pertain in relation to payment 5. In relation to payment 5, they never got a TPA at all. And is it commercially acceptable conduct to allocate a payment that you get from a third party with no explanation as to how it's been used without authorisation being in your hands? And we submit it's not commercially acceptable. Any one of those 3 will do, but we actually say that you can look at it, you can analyse the position in relation to.
And the fact that there had been 4 payments and a course of dealing as practice established is irrelevant, is it?
Well, it doesn't get them over any of those humps we submit, because the critical point being they asked for the TPA repeatedly. If the evidence was, well, we'd had this course of dealing, we didn't think we needed authorisation, we thought it was implicit, so we didn't bother asking for a TPA, it was all okay. That would generate different questions as to whether that was a reasonable position for them to have adopted, and you could look at causation and good faith and all the rest of it from that perspective. But that would be a different set of questions. But the evidence isn't that. The position is they asked for the TPAs, and you saw the cross-examination of, I think it was Mr. Gokada. Yeah, they wanted a TPA, they asked for it repeatedly. Now, we don't know why management took the decision that they did, but they took the risk in making that decision in my submission. Now, there is one wrinkle to the payment 5 argument, which I should mention, which is raised in my learned friend's skeleton, which is that they say that part of payment 5 was allocated to a historical contract that was already the subject of a TPA under one of the payments 1 to 4. And we don't gainsay that, but that's, I think, £336,000 of a 4.4 million odd payment. So part of, it might be said that in relation to a slice of payment 5, they didn't assume the risk because they already had a TPA in respect of that slice in their hands. But in respect of 4 million odd of payment 5, that can't be said. They certainly did take the risk in relation to that. And just for your note, that's paragraph 55 of my learned friend's skeleton at page 50, at page 55 of the core bundle. So, my lady, my lords, that's what I wanted to say, and I'll now hand over to my learned friend, Mr. Mohammed Bai, to address you on the application.
Yes, Mr. Mohammed Bai.
My lord, my lady, good afternoon. May I just confirm that your lordships and ladyship have an additional bundle?
We have a slimline bundle for your part of the case.
I'm grateful. It's common ground that in order successfully to establish its change of position defence, Trafigura must show that it has suffered detriment by reason of that change of position. The detriment which the judge found that Trafigura suffered is that Trafigura continued to trade with Falk following receipt of the payments from Rasmala.
Yeah.
For your reference, as the finding made by the judge, at item 98 of core bundle, tab 7, page 90. Mr. Adkin has addressed the question of the causative link that is needed between Trafigura's enrichment, here the payments received by Trafigura from Falk, and Trafigura's change of position. What this proposed new ground is concerned with is the question of the detriment which Trafigura suffered. The application to pursue on this ground is opposed by Trafigura,
Yes.
both on the basis that it has no real prospect of success and also on the basis that it is late.
Yes.
And so I will deal with the merits of the application, both to deal with the point about no prospect of success and also to develop the argument on the assumption that permission is granted.
Yes. Are you going to deal with the
I will
lateness?
then finally deal with the delay point
Right.
towards the end.
Thank you.
Now, the starting point is that the burden was on Trafigura to establish all the elements of the defence of change of position. The judge correctly recorded that at para 78 of the judgment at core bundle tab 7, page 86. The factual position is that prior to the receipt of the first payment from Rasmala, Trafigura had an exposure of around $12 to $14 million to Falk, in respect of unpaid debts. That's the factual finding made by the judge at para 104 of the judgment. That's at core bundle, tab 7, page 91. And
That was the figure at the date of payment one, immediately prior to payment one, is that
prior
right?
to payment one. Yes.
Yeah.
And the judge says there, surprisingly, there's no documentary record of the running account between Falk and Trafigura. Nevertheless, Mr. Maru's evidence, which I accept, is that immediately before payment one, Falk had reached the extent of its credit limit with Trafigura. That credit limit was 10 or 11 million. At that point, Trafigura had an additional exposure on demurrage of somewhere between 1.7 and 3 million, giving a total approximate exposure of somewhere between 12 and 14 million.
Yes.
Then he deals with the position after Trafigura had stopped trading with Falk, i.e. after payments 1 to 5. When Trafigura eventually stopped trading with Falk, it was owed approximately 12 million and about 3 million in demurrage, a total of about $15 million. Trafigura was in a slightly worse position from having continued to trade with Falk than it was before payment one. But the judge then makes that important finding. Trafigura was able to make some recoveries from Falk and to claim on its credit insurance to reduce its overall loss to $7 or $7.5 million. $7.5 million. So just pausing there, if one were to compare the position before the receipt of the first payment from Rasmala and the position after the receipt of payment 5 from Rasmala, Trafigura was in a better position after the receipt of payment 5 than it was before receipt of payment 1. And that's because, as we've just seen, the judge found that the loss before payment 1 was in the region of $12 to $14 million, and its loss after it had stopped trading with Falk was $7 to $7.5 million. And if one were to stop the analysis there, Trafigura would not be able to say that it suffered a detriment as a result of its change of position, because Trafigura was better off by an amount in the range of $4.5 to $7 million as a result of having continued to trade with Falk. The 4.5 to 7 depends on which figure one uses from the range of figures provided by the judge. This in turn means, again, stopping there, this in turn means that unless and until Trafigura makes a payment to Rasmala of a figure within that range, Trafigura would not have suffered a detriment by reason of its change of position. Now, Trafigura says that that's not a fair comparison because one needs to consider what would have happened in August 2017 had payment 1 not been received. And what Trafigura says, and what the judge accepted, was that it lost the opportunity to stop trading with Falk before payment 1 and take steps to recover its debts. That's paragraph 107 of the judgment over the page, and we make that finding in the first sentence. In addition, Trafigura lost the opportunity to stop trading with Falk before payment 1 and take steps to recover its then debts. Now, just pausing there, for the purposes of this appeal, we accept that a lost opportunity can count as a detriment. And we also accept, for the purposes of this appeal, that it is not necessary for that lost opportunity to be quantifiable in the sense that the court has described a precise figure as to how much could have been recovered from Falk had Trafigura stopped trading with Falk before payment 1. So if we go to paragraph 103 of the judgment, at page 91, we do not dispute what the judge says there in that paragraph for the purposes of this appeal. He says, detriment does not necessarily mean financial detriment, or detriment capable of being measured in financial terms. He refers to Commerzbank, and then he says, where the detriment can be readily quantified, change of position will provide a defense to any part of the claim, and only to the extent of the detriment. Where the detriment is not quantifiable, but is substantial and irreversible, it may be inequitable to require any repayment. See, for example, the decision of the High Court of Australia in the Australian Financial Services case. The difficulty, we say, arises from the fact that, based on the judge's own factual findings, that alleged loss of opportunity should not have been given any weight, because the evidential basis for it was too weak. And we can pick that up at paragraph 104 of the judgment. We've looked at the first bit of it. I just want to focus on the final two sentences of that paragraph. So the penultimate sentence reads, credit insurance would also have been available if it had stopped trading with Farland before payment one and sought to recover the then outstanding sum. Now, again, just pausing there, credit insurance being referred to is the credit insurance that Trafigura said it had, which provided cover for an amount equal to 50% of Trafigura's exposure to physical sales of cargo,
Yes.
but not interest and demurrage. Then he makes the critical finding in the final sentence of 104. He says, it's impossible to say with certainty whether it would have been able to make greater or lesser recoveries if it had stopped trading with Farland before payment one was received. Now, we say that a finding that it's impossible to say with certainty whether it would have been able to make greater or lesser recoveries if it had stopped trading with Farland before payment one was received is far too evidentially weak and vague to count as a lost opportunity. The judge is effectively saying that anything could have happened, and it's impossible to say whether Trafigura would have suffered a detriment or not.
I don't think it's impossible to say with certainty is synonymous with anything could have happened.
Well, my lord, the judge is contemplating the possibility that Trafigura would either make greater or lesser recoveries. Depending on what happened, that would leave Trafigura either in a position of being better off or worse off than what it was at the end of the transaction. The judge could well have said, well, they had credit insurance, and although I can't quantify what they would have recovered under the credit insurance, I accept that they lost the opportunity to claim under it. But he did not make that finding. And as we'll come on to see, he did not do so because Trafigura's own evidence in Mr. Murray's witness statement, which I'll take you to, did explain that Trafigura did not in fact want to make a claim under credit insurance. So it's perhaps
Well,
not surprising
sorry,
the judge made that finding.
In the actual recoveries made were both under the credit insurance and directly from
Correct.
Farland,
Yes,
presumably in its insolvency.
yes.
So
I believe it's an insolvency. I don't know, but it had made
if
recoveries from
if you take this back to the position that just before payment one, both of those routes would also have been available, and at the time Farland was not in insolvency, of course. So you can't just focus on the credit insurance bit.
I'll come on to the bit about the findings the judge made about recoveries from Farland, because he deals with that at paragraph 107 of the judgment. I'm dealing with credit insurance at the moment,
Yeah.
and my submission is that the finding the judge made in relation to the availability of credit insurance is far too vague to count as a lost opportunity. And as I've said, there was some evidential grinding, there was an evidential basis for that finding because of what Mr. Maru said in his witness statement, which I'll come on to show you in a minute. Now, the burden was, of course, on Trafigura to establish detriment, and we say that that finding by the judge means that he has found the prospect of recoveries under the credit insurance to be highly speculative, and such a highly speculative prospect of recovery cannot, in our submission, amount to a lost opportunity. There must be some firmer evidential basis before an opportunity is treated as substantial enough to count as a lost opportunity, which is treated as detriment for the purposes of the defence of change of position. Again, to be clear, we're not saying that it was necessary for him to quantify the lost opportunity and give it a mathematical figure, but it had to have a firmer evidential foundation than the one found by the judge. And the same point can be made with greater force in relation to the findings made at paragraph 107. I've shown you the first sentence. He goes on to say, Mr. Maru's evidence was that Trafigura's dealings with Farland would have been very different if the payments had not been made. His credit team would have prevented further deliveries to Farland and further contracts with Farland, and Trafigura would have placed pressure on Farland to pay, involving the legal team if the payment situation did not improve. That is a lost opportunity to take a different course which is not quantifiable. And then these are the next few sentences are key. It's impossible to say what recoveries Trafigura might have achieved if it had followed that course, but it is possible that it would have been able to make greater recoveries than it was able to make when Falk eventually failed. This is not a remote possibility. Falk had access to several sources of financing, and it is not fanciful to suggest that if Trafigura had demanded repayment, Falk would have found funds from elsewhere to repay, so that it could keep trading with other suppliers. This is irreversible detriment, which is substantial, while I do not accept Mr. Nadine's submission that unquantifiable detriment provides Trafigura with a trump card, which makes its change of position defense unanswerable. I accept that the substantial and irreversible detriment may mean that the retention of a payment made by mistake is not a disproportionate and or unfair outcome. Now again, in our submission, it's not enough for the prospect of recoveries not to be a remote possibility or not fanciful for that prospect to count as a lost opportunity that is substantial enough. Something more is needed, because otherwise any lost opportunity, provided it is not remote or fanciful, would enable a defendant to say that it has suffered a detriment. And that, we would suggest, would open the door to highly speculative detriment being relied on by defendants in order to make good their defence of change of position. Now, what the evidential threshold which the defendant must meet before a lost opportunity should count as a detriment does not fall to be decided on the facts of this case, because whatever that threshold is, it cannot be enough for an opportunity simply not to be remote or impossible to ascertain or not fanciful. And so we say that in the light of his own findings, the judge should have found the opportunity that Trafigura claimed to have lost did not qualify as irreversible detriment. Now, Trafigura says that we're trying to challenge the judge's factual findings, but that is absolutely not what we're doing. The proposed ground of appeal is very much based on the judge's own findings. What we're seeking to challenge is how the judge applied those factual findings to the requirement that there be substantial and irreversible detriment. Now, one of the points taken by Trafigura is that there was somehow unchallenged evidence at trial on this issue, and that we're now seeking to go behind that unchallenged evidence. And in our submission, that's not the fair representation of what happened at trial. I've mentioned Mr. Maru's statement. Mr. Maru was the regional credit manager for Trafigura at the time, and he gave some evidence about what Trafigura may have done if some of the Rasmala payments had not been made. And we can pick it up at paragraph 48 of Mr. Maru's statement. That's a supplementary bundle, tab 2, 45. And just for your note, that's the paragraph referred to at footnote 8 of my learned friend's skeleton argument opposing this application, where they state that this evidence was not challenged.
I'm afraid I missed the reference. Tab 2.
Tab 2, page 45.
Thank you, I'm so sorry. Yes?
We can skip the first part of paragraph 48. It's really, the relevant bit starts from the final sentence on page 45, where Mr. Maru says, our dealings with Falk would have been very different if Trafigura had not been entitled to retain this $15 million and apply it every deal, as Falk would likely have been persistently above its open credit limit during this period. In this situation, as I've explained, the credit team would have stopped further deliveries to Falk, and Trafigura would not have entered into more contracts with Falk, and I would have expected harsh, as Mr. Gisani, to put a lot of commercial pressure on Falk. Ultimately, I believe would have also slowed down trade with Falk, potentially winding down trading altogether and involving the legal team if the payment did not improve. It would have been the credit team who would have taken the decision to pause delivery to Falk, and that decision could not have been overruled by an operator or trader. This would have reduced Trafigura's exposure to Falk and maybe even avoided Falk having outstanding liabilities to Trafigura, it would not have been an option simply to increase Trafigura's credit insurance coverage because Trafigura still had the residual risk under the policy and was not comfortable taking such a risk on a company with a high probability of default. Also, this is an important sentence, claiming under a policy could impact Trafigura's ability to insure other counterparties. Now, that evidence, we would suggest, was hopelessly vague as to what was likely to have happened had payment one not been made. It makes some vague reference to potentially involving validity. And in particular, and importantly, it does not say that credit insurance would have been claimed. On the contrary, it appears to be saying that Trafigura would have tried to avoid claiming under the credit insurance because that would have had a negative impact on its ability to insure other counterparties. So there was nothing to challenge, as it were, on the question of whether credit insurance would have been claimed, given what Mr. Maru was saying. Now, it's fair to say that Mr. Maru was also cross-examined about this. For your note, that's at Supplementary Bundle, tab 6, pages 154 to 155. And
Yeah, it's just pausing. It's not saying that the credit insurance recovery wouldn't have been available. That would have been there as an asset.
it would have been, but the burden is on Trafigura to establish what the position would have been had payment one not taken
Right.
place.
I'm not understanding you to say that there was a burden that wasn't discharged, that credit insurance was available at all. The implication of the witness statement is that the credit insurance is there. You're making a different point.
Yes.
Which is Trafigura may have chosen not to claim on it.
Yes.
I'm not sure whether it's
That was all part
given
of,
it's got a right, it would have a right to claim on it. I'm not sure how important that point is, but I think that's the point you're making.
that's the point. And that's all part of the factual matrix the judge had before him that led him to make the findings that he did at the end of paragraph 104.
Can we look at the, you said there's a brief passage of cross-examination
Yes.
about this. Can we look at
We
it,
can look
please?
at that. It's at the supplementary bundle, tab 6, page 154.
Yes,
Internal page 76,
yes.
line 4. So,
Bit before,
it's actually
looks
line
okay.
line
Looks as
5.
though it's a bit,
Page 154.
looks as though it goes up to, there's some questioning in 75 too.
Yes, it starts with the question on internal page 76. Okay, well, even taking your lowest figures, 11.7 million, you were out, whereas you were only out 7.5 million. So that, there's some exchange. So even at that moment, if hypothetically Trafigura had decided not to continue with business with Farlin, we would have, and Farlin had not paid, we would have still made a claim on the insurance, and the insurance recovery would have been 50%. Trafigura would have suffered 50% loss at that moment as well. Yes, but you did claim the insurance. Yes, you can't claim it twice, Mr. Maru. Justice Roger, then that's what he's saying. No, but I'm saying you would have claimed on that. That's right. I'm just comparing the position that you were in. 17, your figures, and then there are some exchanges. He continues on page 77. I'm not sure you're putting that clearly as ... Okay, you could. So in August 2017, you were owed for physical sales, you say between 9 and 11 million. You say these are estimates, and demurrage, let's say, I think you said 1.7. Yes, to make it easier for me, if we say 11 million physical cargoes, and I appreciate you have said 9 to 11, and 2 million demurrage, you get to 13 million that you're owed by, that Trafigura is owed by Farlin in August 2017. Yes, do you agree with me? Appreciate your caveats, it might be lower. And it goes on, okay, 13 million, at the end of the story in 2018, you're owed, let's say, 7 million, right? That's the period we're talking about. In September 2018, you're owed 7 million. It goes on, let's compare apples to apples, is what Mr. Maru says.
Yes.
And Mr. Maru then says, comparing apples to apples, you're not comparing apples to apples. When we look at August 2017, assuming the numbers that are mentioned are 9.59 to 11, that takes Trafigura to 4.5, 4.5, on the recovery front. On the loss front, 4.5 to 5.5, plus 1.7, the loss related to marriage. That takes me, if my math is right, to 6.2 to 7.2 on the net loss they would have suffered at that moment. Higher numbers they have, 7 to 7.5 million, mentioned in 62. Well, it may just they will have to debate that in front of the lordship. My point to you is that this is not the appropriate comparison because, of course, you paid the money of 11 million in August 2017. You applied the Rasmala money to the historic debts as you had those cleared. The question was, then another point made, why did you debate in front of the lordship, ... go over the page. At the moment, the answer given by Mr. Nugee, at the moment on August 2017, the entire objective was to be in a better position than we are right now.
Yes.
Overdues, and if those overdues are cleared, then yes, we're in a better position. So during the course of his cross-examination, he does float the possibility of credit insurance being claimed. That's what he says. But crucially, that's not what he said in his witness statement when he was giving that evidence in the passage that I showed you. And we said that the judge would no doubt have considered that oral evidence together with Mr. Murray's evidence in his witness statement and reached the conclusions that he did in the passage of the judgment that we've been through. And all that the judge felt able to conclude was that the prospect of recovery was not remote or fanciful, and that did not provide a sufficiently sound evidential basis for him to conclude that Trafigura lost an opportunity which was substantial. And it would therefore respectfully suggest that the proposed ground of appeal plainly has a real prospect of success, and if permission to pursue it is granted, it should be allowed. There would then be the question of what Trafigura would be required to pay to Rasmala. As I submitted earlier, Trafigura is currently better off than it was before payment 1 by an amount in the range of $4.5 to $7 million. And the sensible and just thing to do may be to go for a figure in the middle of that range and make an order for payment in favour of Rasmala in the amount equal to $5.75 million. That's all I was proposing to say on the substance of the application, and I need to turn to the question of delay. In terms of the test that the court should apply when determining whether to give permission when a ground of appeal is sought to be pursued out of time, my learned friends have helpfully made reference to the Court of Appeal's decision in Lighting and Landscape Relief, which is at tab 22, page 709 of the authorities bundle. And that case suggested that an application for permission to pursue an additional ground of appeal is made out of time, the court will apply the principles applicable to late amendments to statements of case, but will also have regard to the three-stage Denton test. We can pick it up at tab 22, page 716 of the authority.
I think you can just give us the references. I mean, this is well-trodden ground
Yes.
in principles. Just
Well,
give us the references unless there's a particular point you want to draw from the.
The facts of that case were helpful in that, like in this case, I would suggest, although there had been some delay in pursuing that ground, that delay didn't cause any prejudice to the respondent. They had ample time to prepare for.
What are in summary, what are the principles you say we apply? In summary.
In summary, it's a combination of the Court of Appeal has said it's a combination of the test for amendments and the Denton test.
Yeah.
Whichever way one applies it, the key feature of the facts of this case is that there's no prejudice to the pursuit of this ground of appeal. And in the light of that, there is no reason why permission to pursue this ground should not be granted. Those are my solutions, my lord, unless I can some further.
Thank you very much. Right, now, Mr. Kitchener, how are you going to deal with matters?
So I'm going to start, if I may, just by setting out what we say is the legal structure governing defences of the kind that we're currently concerned with. Then I'll proceed just to set out a summary of where we are globally, then the facts, the law, and the individual grounds so far as I need to cover them. But I think you will be most assisted just by some general observations about how, as I say, how these defences work, because we do say with respect that there is some confusion, in particular confusion that infects my learned friend's position on causation. And that may result from the fact that he's analysed causation before he's looked at good faith. I just want to explore some of the issues that arise. So, my lord, I think it's common ground that the ultimate question is essentially the question that the judge posed in paragraph 93 of the judgment. A defendant can escape liability and unjust enrichment where his position has so changed that it would be inequitable in the circumstances to require him to make restitution. And it's interesting, isn't it, my lord, that that's in the passive sense. It's passive rather than active. You're just looking at has the position changed to essentially to the detriment of the receiving party. Now, when addressing that question in the context of circumstances such as the present, the court's inquiry, as I've said, is into whether the recipient has suffered a detriment that has a relevant causal link to the enrichment, such that it's inequitable to require the enrichment to be reversed. And I can use that term instead of disenrichment, perhaps. Now, we say that's on a but-for test. And that's clear from a number of authorities, but it's also clear from the fact that in English law now it's established that we use the wide test rather than the narrow test. And you've seen some exploration of that. And as you inferred, my lord, perfectly reasonably from my body language, we do say that the fact that the English law has adopted the wide test is actually very important for resolution of this appeal. I'll come on to explain a little bit more. Now, my learned friend had some difficulty in explaining to you the precise rule that he said applies in cases of this kind. In their skeleton argument, they use the terms effective cause or operative cause, which are terms with which we're all familiar when we're looking at questions relating to the recoverability of damages in tort. But my lord, in the Commerzbank case, I'll take you to it later, this court expressly rejected the importation of the tort rules into this area of law, and they said, I'll just quote if I may, the need for a sufficient causal connection should not be narrowly applied. The important point is there should be a relevant connection between the change of position and the actual or anticipated payment. And, my lord, it's in that context that you should read paragraph 99 of the judgment. We could just have a quick look at that. I'll be coming back to it. Obviously, TPAs are not common or standard practice in the industry, but it's Trafigura's policy to have them, picking up on my lady's point, whenever it receives a payment from a third party.
So you say that that interpretation the lady suggested for Mr. Maru's evidence?
Yes, exactly.
He was talking generally, not specifically.
Exactly. That's just a standard. That's just a standard requirement, and it is.
Clue's in the name.
I'm sorry, my lady?
Clue is in the name.
The clue is in the name. And if I may be forgiven for using a theological term, as the judge also explains, it's supererogatory, a TPA. It's not a legal requirement. It's good practice. It's not common practice. It goes above and beyond. what good practice requires and certainly what the law requires. And that's obviously important in relation to my learned friend's point on payment 5. He says the absence of payment of a TPA on payment 5 makes the change of position defence impossible.
Can you excuse my ignorance and explain in what way supererogatory is a theological term and what it means?
Oh, sorry, it just means in excess of one's obligations. I apologise. In excess of one's obligations, and I'll show you in a moment what Mr. Bitcon said about that. But as I say, it's not a legal requirement. Now, the person relying on the defence, and again, this is important when one starts to think of my learned friend's causation point. The person relying on the defence must have acted in good faith. And the question here is simply, did Trafigura believe in good faith that it was entitled to use the money for the purpose that constitutes the change of position, the detriment? It's simple as that. That's the start and end of the inquiry. We certainly say the judge was entitled on the basis of the evidence to give the answer that he did. And I'll take you to the cases that show that good faith is to be contrasted with negligence. Starts with Dextra in the Privy Council. But my learned friend took you to some passages in Nairu Battery, which is one of the leading cases, and he showed you the paragraph 135 of Mr. Justice Morbick's judgment, where he said that the test is, has the conduct been commercially acceptable, essentially? But of course, what he's focusing on there is the understanding of the payee. What does the payee think it's doing? And in relation to good faith, the key paragraph actually is one that I'm not sure that my own friend did show you, but it's paragraph 110
Of the first
of the
instance.
judgment. Sorry, my lady?
Mr. Justice.
Of the judgment, I do apologise. No, of the judgment below, I apologise.
Hang on, do you mean the judgment in the case or the judgment?
The judgment below, of this case.
This
in
judgment.
case, I apologise.
110.
Oh,
Paragraph 110.
Not very good.
So this is the key in relation to good faith and risk allocation, I suppose, as well.
Yes, no, we didn't look at this. I don't think.
No, I don't think you did. But this is where I'm going to eschew theological references from now on. But this is where we get Trafigura's insistence on TPA being good commercial practice. You've seen in paragraph 29, the judge has said it's not common practice. But no one in Trafigura knew about the terms of the Murabaha. And this was as Rasmala intended, having authorised Falk to act as the undisclosed principal. As far as Trafigura was aware, Rasmala was simply providing finance. I accept the evidence of Trafigura's witnesses. They wouldn't normally deal directly with the customer's financiers. They thought they were dealing with Rasmala through Falk. So again, you're looking at good faith and you're looking at what does the recipient believe when they are taking the act that constitutes detriment.
Where was the evidence? Just so we know, I'm not necessarily asking you to take us to it now.
Yeah.
What was the evidence upon which he made the assertion in the second sentence?
The second
That,
sentence.
yes, that no one at Trafigura knew about the terms of the Maraba Fund,
Well,
and
well,
this was as Rasmala intended.
I'm going to.
We're going to do that.
Would you like to see it now?
No. Just look. It's on your agenda.
I mean, my lord's absolutely right to focus on it because it's a key piece of evidence that actually disposes, we say, of many of the elements of this case, including causation, including good faith. But Rasmala sets up this system under which all communications with Trafigura are mediated through Falk. And it wants to avoid Trafigura knowing that Falk is acting as its agent for the purpose of the contract of sale. The reason for that is fairly obvious. It doesn't want to be held liable on the contract of sale. I'll take you to the evidence.
Yeah.
In answer to my Lord Justice Nugee's point about did Rasmala take the bills of lading? It didn't. And again, I asked Mr. Bitcon about that at trial, and he said, well, the reason we didn't want the bills is because the bills expose us to liability. For example, in relation to demurrage or offloading or dangerous goods. So they took a lot of steps to conceal the true position from Trafigura because they had other commercial interests that they wanted to protect. But so my lord's honed in on an important issue, and I am intending in fairly
Right.
early course to take you
In
to
due
that.
course, yes, thank you.
But my lord, again, what's critical when you're looking at good faith is that one is focusing on the understanding of the payee, the recipient. As Mr. Justice Raja found, and this was key to good faith, the TPAs appeared on their face to resolve any doubt as to how Trafigura could use the payments. The fact that Rasmala made further payments under payment 1 reinforced the belief that all was in order. Now, that last sentence is also important when we're looking at the situation after TPA 1. And that has a bearing on the position in well, we now know, or it's now been accepted, that payments 1 and payments 2 essentially fall by the wayside. So you're looking at payments 3, 4, and 5, and the suggestion has to be that despite the findings of the judge, and my learned friend has taken you to some of them, Trafigura ought to have known or suspected that in relation to payments 3, 4, and 5, Rasmala was making a mistake. We respectfully submit that that's just unreal on the facts. One would have to identify what that mistake would be. I mean, Trafigura obviously didn't know or suspect that Farlin was involved in a fraud, but also we know on the basis of his lordship's findings that Trafigura did not believe that Rasmala intended to allocate the payments to historic debts, only to future debts. That's the finding at paragraph 43 that my learned friend showed you, and it's reflected also in paragraph 47. So at that stage, the idea that there's anything in bad faith in relation to the later payments, or that there's any problem with causation in relation to the later payments, is really hard to understand. Of course they're relying on the later payments. The idea that my lord's decision in paragraph, or holding in paragraph 99 on causation, could be faulted in relation to payments 2 to 5, we respectfully suggest is just commercially unreal. So we're focusing on the understanding of the payee. Now in Nehru Battery, the recipient, the bank, actually knew that the payment was made by mistake. There was no question of that. But Mr. Justice Morbick in the Court of Appeal also concentrated on a question that very frequently arises in cases of this kind. It arose in a case that Lord Justice Nugee decided in his prior incarnation as a first instance judge, you may remember, called Webber. And the question is, if one doesn't know that there's a problem but suspects that there may be, what do you do? And the answer is, and you saw the answer in paragraph 135 of Mr. Justice Morbick's judgment, adopted by Lord Justice Clark in paragraph 164, that you've got to make inquiries. And we're all incredibly familiar with that in this area of the law. That's what the law requires. Mr. Justice Morbick makes clear that you can't lay down any a priori rules about what kind of inquiries one ought to pursue. That's necessarily the case because we're looking at what is commercially acceptable. And my lady asked, how do we know what's commercially acceptable? My learned friend said, I think, well, you've just got to use your commercial
Common sense.
But that's actually wrong. You can actually look at the evidence in the case. And I'm going to take you to some of the evidence as to what Mr. Bitcon, how Rasmala conducted themselves and how Trafigura ordinarily conduct themselves.
Well, it's very fact sensitive.
Yeah.
isn't it?
Absolutely, it is, my lady. It absolutely is, and I'll show you the facts of this case that explain why the judge reached the conclusion that it was entitled to reach the conclusion that he did. But before I get to that, can I just, as I say, we're still on sort of the legal structure of how these things work. Can we just focus on the importance of the concept that we find in the cases that where one suspects that there might be an issue, what you have to do is you have to undertake relevant inquiries, which is exactly what Trafigura did, leading to the TPAs. But my learned friend says, well, as a matter of causation, how this defence works, that if you undertake those inquiries and rely on them, well, as a matter of causation, you're not relying on the payment, you're relying on the results of the investigations, so you fall at the hurdle of causation. Now, well, one indication that he's going wrong was the extent to which he had to, in the course of his submissions, just pick and choose those statements made by Farlin that he said Trafigura essentially are bound to accept as true, and those statements mediated through Farlin that appeared to come from Rasmala that it was not entitled to rely on. So he started off in relation to payment 1 saying, well, Trafigura knew that Rasmala didn't want these payments to be allocated to historic debts. How did Trafigura know that? The only person with whom Trafigura was communicating was Farlin. So he says, where you're asking Farlin at that point, well, obviously you're stuck with that. But then when Farlin says, well, actually, we've persuaded Rasmala...
Relented. They've relented. So,
when they've relented...
or Mr.
That's
Mandani relented.
That's not something. That breaks the chain of causation. Even though what they provide us with is what appears to be sort of the gold standard confirmation, which is a signed agreement that we don't know is forged and that we think resolves all doubt, as is made clear in paragraph 110.
Not only don't know it's forged, but I think the judge finds that you had no reason to suspect.
Of course, exactly. No red flags. Paragraph 75, paragraph 112 and 113. I mean, what the judge finds in paragraphs 112 and 113 is that there was no reason for Trafigura to believe that anything was wrong with the TPAs or that any of the payments were returnable and made by mistake. And that's the key, actually, in relation to payment 5. So in relation to payments 1 to 4, you've got the judge's conclusions that the TPAs sort things out. But in relation to payment 5, you've got his finding in paragraphs 112 and 113 that there was no reason to believe that any of the payments were repayable and that no one at Trafigura thought that any of the payments were repayable. And that's just dispositive. I don't want to spend too much time investigating what the potential consequences might be of accepting my learned friend's submission. But, for example, what would happen if instead of getting a TPA, Trafigura took legal advice? They relied on legal advice to the effect that they could disperse these monies or use these monies in the way that they wanted. In my respectful submission, that would be acting in good faith, and there'd be no causation issue. What you're doing is you're relying on the validity of the payments.
Can I just go back?
Yes.
You say that one of the problems with the appellant submissions is sort of starting with causation and coming to good faith later. Whereas
Yeah.
you start with good faith, why do you say that's the right approach? Do you say that's the fundamental way in which the offence has been developed? That's the starting point.
Yeah, I'm sorry, Melody, I didn't quite catch the question.
Well, it's why you say you should start with good faith
Yeah.
rather than starting with
Well,
causation.
because what you've got to identify whether there is a detriment, and I accept that you need to establish that there is a relevant causal connection between the detriment and the receipt. That's quite clear. But where that, what I'm saying is, first of all, I say the test is just but for, and that's clear from the cases, it's clear from the wide approach. But what I'm trying to do at this point of my argument is to show how there can be a causal bridge between what you do in order to comply with your obligation of good faith and the causal requirement. Because if you've got a payment and you're trying to establish that you're entitled to use it for the purpose for which you want to use it, that's what the law says you must do. It just cannot be the case then that those making those inquiries and relying on the results of them break, and this is what my learned friend has to show. He has to show that it breaks the chain of causation.
Okay, I understand that better now. You say you say that your Trafigura were just making inquiries as good faith obligations might or indeed might not have required them to make. You say that can't be enough
To break the chain of causation.
Whatever the causation.
Whatever the causal test is, whether it's an operative cause, needs to be an operative cause or an effective cause. I mean, I'm going to come on to address the question, the important question again that my lord put to me: where is the evidence that Rasmala intended Trafigura to communicate with it through the medium of Falk? And I'll show you that, Evan, because again, that's, we say, essentially dispositive of the question of causation. Because what we do in relying on communications mediated through Falk is exactly what Rasmala knows that we're going to do and intends that we should do. But, my lord and my lady, we also know, because of the cases relating to the wide view as against the narrow view, that the detriment needn't be the result of reliance by the payee on its belief that it's entitled to use the money at all. So the example, and my own friend took you to Scottish Equitable. There's also a case of Delta Oil in the Privy Council. But Scottish Equitable gives the example of, well, what happens if the money is stolen? Again, there's no reliance at all by the payee, whether on the payment, on the validity of the payment, or anything. Now, the reason that's important is that it kills dead any notion that there is any a priori requirement that you need a valid communication by the payer that plays any role in the causal chain. And it illustrates the fact that the enrichment just needs to be a but-for cause. Because where you have a payment followed by a theft, you certainly wouldn't say, would you, that the payment was the effective cause of the detriment. You wouldn't say it's the effective or operative cause of the theft. Now, I mean, our facts, we say, are much stronger than the theft example. We do rely on the payment. And we say there's just no conceivable causation test that isn't satisfied on the facts of the case. The payment was made by them intended to fund purchases of coal. It was used for that purpose, where otherwise we wouldn't have supplied more coal. The key importance of the TPA is just that it allows us to allocate payment against historic debts, but so far as we're aware, that makes no difference to anyone. And my learned friend says, well, it's important to Rasmala because of their Murabaha agreement, but we don't know anything about it. And importantly, my lord, none of the Trafigura witnesses are cross-examined about why they think allocation would be of any cause of concern to Rasmala at all.
Just to be clear, internally allocation is important because without that allocation, it is clear that Trafigura wouldn't be prepared to continue trading. So internally, it's clearly important. That obviously has an effect externally.
Yeah.
Because and Falk must have known about this because there was the discussion. It in fact allowed the continued trading. So the allocation was important.
Well, it was important as an internal matter for Trafigura.
Well, it's important because it allowed it. Yes.
Yeah.
It did allow continued trading.
And that's what Mr. Maru. So Mr. Maru, the credit guy, he was the one who insisted on it. The traders couldn't have cared less. They didn't care how the payments were allocated. All they were concerned with was, well, you know, what's happening to the credit limit. And from the trading sense, it really didn't make any difference at all. Because what happened, it didn't matter what the payments were allocated to, it freed up the credit limit for further trading. And it's important also to bear in mind that the loss that Rasmala suffered was absolutely nothing to do with any internal allocation of the payments in Trafigura's books and records. The reason that Rasmala suffered a loss was because it was meant to get paid from the proceeds of the sale, and Falk fraudulently diverted the proceeds of sale away from Rasmala.
Well, as I understand it, there weren't even any proceeds of sale because the coal contracts were themselves fake.
The proceeds of sale of the further trading.
Yes,
So there was
but
further
the
trade.
specific trades that
That's
Rasmala
right.
thought
My
it was
lady's
funding did not exist.
My lady's right. And Falk arranged for end buyers to provide assignments to Rasmala, but they turned out to be forged. So we're not the only people to be taken in by forged documents. We know that Rasmala also relies on forged documents produced by Falk. Most importantly, of course, the contracts of sale, the Trafigura contracts, they're forged. And Falk accepted. It doesn't mean that that Rasmala hasn't acted in good faith. So it's, again, we're criticised for accepting as real contracts produced by Falk that turn out to be forgeries in circumstances where we're just one of a list of people who
Well, a classic situation for restitution cases where
absolutely
who's suffered most.
it is, and where does the actual line? But the key is, of course, that Rasmala has a number of choices that it makes, and my little friend was pressed on this on a few occasions. And again, we asked Mr. Bitcon some questions about this in cross-examination, as you can imagine. So the choices it makes are, first of all, to trust Falk by extending credit to Falk. So on the basis of its own due diligence, it decides that Falk is creditworthy and trustworthy. Then it applies Falk to act as its undisclosed agent in the purchase of coal. And it chooses to conduct all communications with suppliers through the medium of Falk. Something that we're obviously criticised for having done. But Rasmala knows and intends that the only information we get from them is delivered through the medium of Falk. Shortly before, just coming back to the wide view and why it's so important, just before the short adjournment, my learned friend was asked, well, if theft is enough under the wide view, why is not being defrauded? I think it was my Lord Justice Nugee. And my learned friend just said, well, that probably wouldn't give a defence. So which our question is, well, why not? I mean, if you've got a defence, if the money is just stolen, why don't you have a defence in circumstances where Farlin, which is the party that is being financed by Rasmala intentionally, and the party that's responsible for conducting communications between the two, it commits a fraud? Why, we ask rhetorically, would that not be sufficient in terms of a causal test? Now, that's sort of an overview of how we see the legal structure. It was intended to be a sort of roadmap, but I'm afraid I got a bit over enthusiastic when I was making notes to my notes, hearing my learned friend's submissions. But if I could,
Well, we won't ask you to navigate on that. You tell us where we go next.
I'm great.
We ask optimistically.
So I was going to start with what you think you may already have got, which is a summary of our position. But the ultimate finding, I've shown you paragraph 93, and the ultimate finding of the judge is at paragraph 108 of his judgment on the basis of his other reasoning. So in the circumstances of this case, it would be inequitable to require Trafigura to make any repayment. And we say that was a conclusion amply justified by the evidence. Rasmala made the payments under a mistake. Had Trafigura not received the payments, it would have stopped trading, would have made no further deliveries. The judge, as you saw, held that we had no reason to suspect and didn't suspect the payments were made under a mistake. It's not clear to us that any of that is challenged. And given that it's not challenged, it does put into sharp focus the results that the appellants are asking you to accept. So the entire claim arises by reason of Rasmala's mistake. Rasmala made monies available to Farlin in order to finance the purchases of coal. The money was used for that purpose. I've shown you that we had no visibility over the nature and terms of the financing. The fact, and I promise to take you to the evidence in a moment, but the fact that Farlin is acting as undisclosed agent is actually quite a good, shines quite a useful light on the fact that the relationship between a coal trader or any trader and their financiers is essentially private to them. And that we'll see some evidence about how that's regarded in the market, but it casts important light on whether it's to be regarded as, whether there's anything strange about the supplier communicating only with its customer rather than with its customer's financiers. Because the relationship between the financier and the customer is essentially private. We've talked about...
You could say it's intrinsically risky because in a certain...
Sorry, my lady, I didn't catch
You
that.
could say it's intrinsically risky because the financier might be presumed to know that that financier wouldn't necessarily be financing every trade that the purchaser enters into. And as we've seen, if there are a lot of trades, from the point of view of the supplier, there's a single account. With what it thinks is one counterparty.
My lady's actually right. I mean, one can see lots of...
You might think that's an important structural risk.
Yeah, I mean, there are lots of circumstances in which people really don't want their relationships to be interfered with.
You could have structured the same deal from Rasmala's point of view. Rasmala making the money available to Farlin, and Farlin
absolutely
paying it on to you.
Exactly.
Rasmala could have agreed with Farlin it was only to be used for A, B, and C. If Farlin then uses it for D, that's
Exactly.
they wouldn't have a claim at all.
And from our perspective, there's no difference. From Trafigura's perspective, why is there any difference between the situation that my lord posits and the situation that actually it knows about? There's nothing that gives rise to any sort of suspicion. All Trafigura knows about is that Rasmala is providing finance to Falin. As you're absolutely right to say, an alternative structure could have been just payment Rasmala, Falin, Trafigura. From Trafigura's point of view, it doesn't make any difference. Now, Rasmala made 5 payments to Trafigura for a total of over $20 million without any direct communication with Trafigura, either before or at the time of the payments. So if we go to the judgment, I think you saw this earlier, but let's just remind ourselves, the judgment at paragraphs 27, 28 and 29. So Rasmala sent Falin a letter to be provided to Trafigura. So where Rasmala intends to communicate to Trafigura, it doesn't send a letter direct to Trafigura, it sends it to Falin for onward transmission.
It is an extraordinary feature for my part in this case that there is no direct communication at all
Absolutely.
between the two parties to this appeal.
Yes,
Except
that we think there is.
Okay, well, carry on.
No, but my lord's absolutely right. And my lord, I infer that my lord is slightly surprised at the idea that a financier thinks it's a sensible thing to do to send all that money to someone with whom it has no communication whatsoever. But more so, and this was you will not be surprised, here was a submission I made below, even more so that Rasmala then wants to shift the risks of having decided to do that to Trafigura.
That letter we looked at page 303 of the
Yeah.
supplementary bundle is it addressed to Trafigura?
I think it is, my lord.
But they leave it to Falin to attach it to an email to send to Trafigura, and we now know
Yes,
that in doing that they removed a critical sentence.
exactly.
Yeah.
Exactly. Intended to gull Trafigura into, obviously, well, intending to mislead Trafigura and conceal the true position. But my lord's absolutely right. That is a letter that's addressed to Trafigura. One interesting, another interesting question that might arise on my learned friend's case on causation. So we rely on a TPA that appears to be signed by Rasmala, and my learned friend complains that it is provided to us by Falin. Well, what would he say, one wonders, if instead of that circumstance, Falin had simply forged a letter from Rasmala addressed to Trafigura and arranged for that to be sent, saying, we're happy for you to allocate the payments to historic debts? Could there possibly be any question in those circumstances, either on causation or good faith, as to whether or not we were entitled to rely on it? The fact of the document being provided to us by Falin, everyone's making such a fuss about that, but actually it's just completely irrelevant. The forgery could have been achieved by Falin just pretending to have Rasmala send us a letter direct. What would the difference be, we rhetorically ask, in terms of causation? Now, Mr. Bitcon of Rasmala, he repeatedly confirmed in cross-examination that Rasmala trusted Falin just as Trafigura did. And I'll take you to the evidence now that my lord asked to see in relation to the chain of communications. It's at supplemental bundle tab 5. page 103. Now, we don't have the various agreements in the bundle, but actually the agency agreement between Rasmala and Farlin actually prohibited Farlin from explaining to Trafigura the precise role that Rasmala was playing in the trades. And you won't be surprised to hear that I had a couple of questions on that when Mr. Bitcon gave evidence. And his evidence starts at internal page 28 from line 16.
Yes.
So you see, Farlin was specifically prohibited from disclosing your involvement, and he accepts that's right.
Yeah.
Then I say, well, he says he offers an explanation, and I said, I'm not asking for an explanation, but I was just asking for confirmation. I get it. Mr. Justice Rogers not quite so permissive of the approach that I adopt in later parts of the cross-examination.
Quite right too.
And
Yes.
I asked him, when you went down that route, the terms of your agreement with Farlin was that Farlin was prohibited from disclosing Rasmala's involvement. That was in the agreement. But then he says, but we were aware Farlin had to disclose Rasmala within the transaction because Trafigura was going to receive money. So they would know Rasmala was the financier. But again, it's Farlin going to be doing the disclosing. But the nature of the dealings and any of the detail, that was to remain confidential, and that was to protect ourselves. And then again, I try and interrupt, and I'm prohibited. But the explanation comes, as you'd expect, in paragraph 30. We wanted to protect ourselves from breach of contract, and I very gracefully observed that had been the hypothesis that I'd put forward in opening argument, not, as you can imagine, by way of self-congratulation, but I thought it was an observation that I ought to make. And then from line 17, and you understood, I think you've said, that Farlin was going to have to say something about Rasmala to Trafigura and making those communications. Farlin was making communications as your agent, wasn't it? The person you trusted to conduct them. That's correct. And Rasmala chose, didn't it, to put in place a structure where only Farlin, its agent, would communicate with the supplier. Yes, that's correct. And you did that because it was important to protecting your perceived legal interest. That's right, yes. It was there to protect ourselves from possible liability. So again, this is this structure, which is the critical part of the architecture of the appeal, was put in place deliberately by Rasmala. And then at page 32, from line 10, we've just been discussing some general propositions at this stage. Would you agree, coming back to our general propositions, that a financier who wants direct communication with a third party is well able to initiate that? And obviously one's expecting the answer yes in that circumstance, to that question, but we actually get the answer no. Not in a number of instances. What we'd seen is that suppliers and also buyers aren't interested in financing arrangements of a trader. They don't want to be involved in that. And I say, it's just not their business, is that right? Say it's the arrangements, the financing arrangements are the financing arrangements of the trader. And then you can read the rest of the page. And then he carries on at page 33 and he says, oh, well, actually, this is where, paragraph 33, page 33, he may have appreciated the problems that evidence has given to his case, and he gives that further evidence at page 33. Then, my lord, at page 36, coming back to the TPAs, so this hasn't been an important part of the case so far, but the transaction with Rasmala didn't just finance supplies from Trafigura, it also financed supplies from other suppliers. We don't need to worry about the substance of that, but the question we asked was, the other suppliers, they didn't ask for third-party agreements. And then he accepts that.
Just where, so
So line 7 on internal 36, my lord.
Yeah, that's your, yeah.
So other suppliers didn't ask for third-party agreements. Payment for, we were requested to provide a document which was similar to the document provided to Farlin with respect to the Trafigura payment. That was the document referring to. Was it similar to third-party agreement? No. It was just a payment, just a document, just a payment confirmation. Yes. Asking for third-party agreements wasn't standard practice at the time, was it? No, we didn't receive any other tripartite agreement requests from anyone. So Trafigura might say, mightn't it, that it went further than was normal in the market to try and make sure it was aware of the true nature and scope of its right to utilise the payment. Would that be fair, given your knowledge of how the market operated at that time? Answer, yes, I'd say that's accurate. So, my lord, we relied on communications, and this is critical for, well, it's dispositive of causation, good faith, risk allocation, however my learned friend wants to make what's essentially the same point. We relied on communications sent to us from Farlin that appeared to be from Rasmala, just as Rasmala knew we would and intended that we should.
But you asked for more, you asked for a tripartite agreement.
Absolutely. Absolutely. But obviously any request of that kind, well, any communication was going to be mediated through Farlin. And that's what Rasmala wanted. And that led, we say, inevitably to the findings that the judge made in relation to causation, risk allocation, and causation, and good faith.
Yes.
And that's why we say that, in essence, what Rasmala is trying to do is to recover from Trafigura the losses they made as a consequence of their own mistake and their own commercial choices. Now, the money was paid under a mistake, and we accept that, but it's important to remember what the mistake was. And the mistake, as we've seen in the judgment at paragraphs 89 and 90, is that Rasmala thought that it was making a payment on genuine contracts. My lord, obviously it is not suggested any longer that Trafigura had any notice or any suspicion or any reason to believe that that mistake was being made. Again, really important to remember what the case below was. So the case below started with the allegation that Trafigura actually participated in the fraud and put the TPAs in place as a fraudulent papering exercise. And it was alleged, and it was certainly was alleged that, and it continued to be alleged even at trial, that the TPAs were put in place without Trafigura genuinely believing that Rasmala had agreed to them. That was rejected by the judge. That's not appealed against. But the judge held on a purely objective basis that Trafigura had no reason to suspect that Farlin was operating by reason of the mistake he found, or any mistake. He held there were no flags. More importantly, that there was nothing to put a reasonable person on notice. Let alone good faith, even on an objective basis, there was nothing to put us on notice.
Yes, the judge makes that finding, but I think the good faith requirement doesn't appear to extend to a purely objective test.
Well, my lady, the way that we say it works is this: absence of good faith requires you to prove a lot more than simply failing to act as a reasonable person would. The reasonable person test is the negligence test, and I might take you probably tomorrow morning to the decision of Dextra
Yes.
in the Privy Council, making clear that negligence doesn't work. So there's got to be bad faith, essentially. And bad faith ordinarily is either knowing of the mistake or failing to make the inquiries that you really know you ought to make. And it's not really asking the queries that a reasonable person would make.
No, something
It's-
that actually puts you on the.
Exactly. Something that you're consciously, subjectively aware of is a problem. And Mr. Justice Morbick in Nauru makes that clear. So my learned friend took you to paragraph 135. At some point, I might take you to paragraph 138, where he explains that the reason that you've got to make inquiries is because otherwise you know that you're potentially infringing someone's rights. And he's focusing on that, the knowledge of the infringement of a right. But it's only when you are subjectively aware that there is a potential problem that you can be under an obligation to make further inquiries. So the suggestion, for example, that we ought to have made further inquiries of Rasmala direct. But that can't arise in this case because not only did we not subjectively suspect that there was a problem with the confirmation that we'd received in the TPAs, we acted entirely reasonably on the judge's findings in forming that view. So we just don't get to the stage of having to make any further inquiries. As you've seen, we go way above and beyond anything the law requires, anything that standard commercial practice requires. You've seen that Mr. Bitcoin accepted TPA's third-party agreements were market leading. It was all done on the basis of legal advice. One of the reasons, I can just mention it forensically and just for your curiosity, but one of the reasons that the dishonesty claim was rowed back from and essentially had largely to be abandoned, other than against Mr. Giussani, was we weighed privilege in the fact that all of this, everything that was done on the basis of legal advice, internal legal advice. And you see reference to that in the judgment at paragraph 31. So what we do is we take the steps that we think are appropriate to ensure that we can use these payments for the purpose that we want. We do it on the basis of legal advice, and ultimately the only fly in the ointment from that can be pointed out is again this question of internal allocation, which from our perspective just doesn't impact on Rasmala at all. We've just got no reason to believe that Rasmala would be in the least bit concerned with how we allocate these payments in our internal books and records. So, my lord, this is just a million miles away from any of the cases in which restitution has been ordered despite a change of decision defence. My own friend relies on Rose. If I've got time for her, I might go back to it just to pick up a few points. But as you remember, in Rose, there are two really interesting things about Rose. So my lady picked up on the fact that there's a lag of time between the receipt of the payments and the release of the charge. And that's important, really, for one key purpose, is it illustrates that the state of mind has to be assessed, obviously, as at the time of the change of position, at the time of the detriment. And obviously, again, that's a really good reason why but for can be the only test, because between the receipt and the detriment, any number of things might happen. Any number of things are likely to happen. Any number of things are likely to influence a decision to spend money, alter one's financial and commercial arrangements. And we're looking at judging the conduct of a party, not as at the date of the receipt, but as at the date of the conduct that constitutes the detriment that's relied on as the change of position. So Rose is important from that perspective, but also the other key is that what the learned judge or the learned deputy judge repeatedly says in that case is that there was no reliance by the bank on the validity of the payments. That's the key. And that echoes what was said in Lipkin-Gorman, if you remember. It's all a question of, are you relying not just on the fact that the payments were made, but on the fact that they're valid payments, that they're payments that you can use for the purpose that constitutes the detriment. And that's why this case and Rose, I mean, it's not just that Rose is distinguishable. I mean, there's literally nothing to compare the two cases.
Right, well, that's perhaps a good point to stop on that rhetorical observation. How are you doing? You said you would need a day, I thought, or you said you might.
I'm sorry, my lord.
How are you doing in terms of your time? You said you were going to be a day.
Oh, at the moment, you will blanch if I tell you how many pages I've got in my notes, but I will assiduously go back this evening.
Well, that's the great advantage of the advantage. It gives you a chance to shorten them.
And I will strike through as many of them as I possibly can.
Yes. As inevitably, I think the issues have narrowed in the course of
And of course, Grand One is gone.
And Ground One has gone as well. But you need to leave time for Mr. Naden to respond
Certainly
on
do.
the amendment.
He deserves his moment in the sun, and he will get it.
Right. Okay. Right. Thank you very much. Look forward to seeing you all 10:30 tomorrow.